Hi everyone, I'm Ross McRae, Group HR Director and Deputy MD at the Orion Group. Welcome to our presentation series on off-payroll working. This is number 6 in the series, and in this presentation we'll look at the additional responsibilities that end users of contractor services will accrue following the implementation of the IR35 changes in April 2020. The off-payroll legislation is about more than just the change in assessment responsibility, but we'll start with a brief overview on that before going on to look at status determination statements, liabilities, and other associate adjustments. If you want more details on IR35 basics, you can find that in the first presentation in the series. But by way of recap, we've highlighted the basic responsibilities in this slide. At the bottom of the screen in orange is a contractor that is providing services, in this example through a recruitment firm, represented in blue by Orion. In green is the client, the end user of the services, who now retains the responsibilities to assess whether the contract worker supplied by the contracting company is a disguised employee for the purposes of tax. Along with assessing whether a contracting personal service company is in or out of scope of IR35, the client is also responsible for conveying their determination back through the supply chain. Where there is an agent in blue on the screen, they are responsible for deducting applicable taxes and social security for in scope of IR35 contractors and paying it, along with the employer's national insurance, to the revenue. They also have responsibility for other compliance issues relating to real-time reporting and the apprenticeship levy. We've mentioned before, but it's worth mentioning again, that size matters, and whilst all public bodies are covered by the changes, only medium to large sized companies are affected by the new legislation. Where contractors work for small businesses, they continue to retain the responsibility for determining whether the IR35 rules apply to their assignment. There's an established small company test which captures companies that meet 2 or more criteria. These criteria are annual turnover of less than 10.2 million, a balance sheet of less than 5.1 million, or less than 50 employees. You'll notice that there's a further box in grey which indicates that the final tax liability may transfer from the fee payer, as an agent is typically called, to the end user or client, depending on a range of circumstances relating to process and timing. Clients should ensure they understand these circumstances so that they're not accruing unexpected liabilities. We'll touch on this later in the presentation. As we've noted, the end user of the personal service company services will be required after April 2020 to assess whether each assignment undertaken by a contract worker is in or out of scope of IR35. Along with this responsibility, there are a few conditions enforced on the end user. They're first of all required to provide a status determination statement, or an SDS, for each assignment undertaken by a personal service company worker. There's not much definition on the SDS format, but it should include the determination and the reasons for it. There's also a requirement on the client to ensure that they take reasonable care when determining an engagement status, but frustratingly, this too does not have any definition around what due care should look like. Another change that's coming for end users is the obligation to share the status determination statement with the next party in the supply chain. Whilst this seems obvious, it is a legal requirement. There's also a duty placed on the client to make available what's been called a status disagreement process, which is effectively an appeal process. Contracting representative groups argue that the appeal process is weak and will not impact initial assessments. However, personally, I would hope that companies will work with the spirit of the legislation and undertake detailed reassessments when, for example, a significant issue relating to assignment was not noted in the first assessment, or something has materially changed in the assignment. The client must complete the appeal process within 45 days, but how it's undertaken is currently completely at the discretion of the end user. They are, however, required to notify their status disagreement process outcome and the reasons for the decision. A couple of important points to note. If a client does not carry out an appeal, the responsibilities of the fee payer, the agency, transfers from the agent to the end user. It's also worth noting that while there are several obligations changing in particular relation to who's responsible for assessing contractor tax status, the criteria for determining whether somebody is genuinely in business on a self-employed basis does not change. They remain as they have done for 20 years. We covered this extensively in our self-determination Part 1 and 2 presentations earlier in the series. We should also remember that HMRC have been undertaking IR35 assessments for 20 years, and the basic principles regarding how they are undertaken remain broadly the same. So what do you do next? You've identified that you have contractors engaged through personal service companies. Well, if the workers are engaged directly to your business and you deem that they're in scope of IR35 based on the assessment criteria, then what you'll need to do is calculate the deemed income, allowing for materials and expenses, deduct employee taxes and national insurance contributions, pay them to HMRC along with employers' national insurance contributions, and comply with real-time information reporting requirements and pay the apprenticeship levy. It's not a light undertaking, and it assumes that the worker wants to remain engaged through the personal service company, which they may not want to given the tax benefit has gone and they still have insurance costs, accounting fees and other business related costs to cover. We'll come back to the next steps once we've had a quick look at potential liabilities, and we'll cover a range of alternative engagement methods in the final presentation, number 7 of the series. When it comes to liabilities, there are unfortunately a few uncertainties. For example, HMRC argue that tax receipts are up since introducing off-payroll rules in the public sector back in 2017, but there's no evidence that IR35 compliance has improved. Other problems relate to the lack of confidence in HMRC's ability to undertake IR35 assessments, their poor track record at tax tribunals, and the fact that the forthcoming changes do not address perceived existing IR35 shortcomings. We've advised that when appeals are not carried out by the end user, then the fee payer's, typically a recruitment company, responsibilities pass to the end user. The same is also true when a fee payer requests an initial assessment and it's not carried out by the end user. Again, the liabilities pass to the end user. There are some deliberate non-compliance protection measures built into the legislation, such as the fact that HMRC may pursue income from another party where tax avoidance or non-compliance instructions have been issued to contractors, or where an end user was aware that non-compliance was occurring through their supply chain. The good news is that putting in place appropriate due process can offset these risks, and we'll provide an example of this in our 7th and final presentation on IR35. So we know that further clarification is required on some aspects of the changes, that the legality of blanket bans will be challenged, and that there's no set answer regarding what happens with incorrect IR35 assessments. We also know that the government developed a system called Check Employment Status for Tax tool, or CEST for short, which has been provided to businesses to assess contractors' employment status, has been contradicted in court, and many argue is not robust enough. Other issues that need iron out relate to the appeals process and restricted appeal numbers, what happens to unresolved status determinations, and what status should a worker be engaged in during an appeal process. These, however, will not impact on the implementation of the legislation itself, and organisations will have to apply practical solutions to these questions. A complaint from the contracting community is that in-scope determinations do not automatically provide employment rights to the workers should they remain engaged through their personal service company. Once you have an appreciation of the legislative changes, it's important that end users put in place a process to prepare and implement a compliant solution. We'll make some observations about market trends on the next slide, but assuming that you wish to retain a flexible contracting capability to outsource work without creating an employment relationship with vendor staff, then you may want to undertake something similar to the 4-stage process. For step 1, you should identify all workers that could be in scope of IR35. This will include any workers engaged through a personal service company, whether through a recruitment company like Orion, or personal service companies engaged directly, or personal service companies that are engaged perhaps through a third-party supplier. Once you've collated your list, you need to decide the method that you'll use to assess whether the workers engaged through these personal service companies are in or out of scope of IR35. You can do this on your own with appropriate advice, or more typically outsource it to a specialist supplier to undertake on your behalf. At this stage, you may want to consider undertaking an impact assessment to prepare for the potential outcomes. This should include transition arrangements for engagement status changes, critical supplier retention, resource attraction, and operational impact. So once the assessment mechanism has been set out and the personal service population identified, the third stage is to undertake the assessments, communicate the outcomes, and implement any engagement status adjustments that are required. We'll discuss this further in the next presentation. The final stage is to prepare processes to ensure future engagements, contract extensions, and engagement renewals are captured, along with ensuring that periodic checks are undertaken to ensure that there are no material changes that may affect the engagement status of the personal service company workers. Each company will find its own route to compliance, as there's no right or wrong method. We've identified 4 primary trends, and each retain their own pros and cons. The first is what we've called a hardline approach. So far, this has been a minority of companies that are typically very large in scale. For a variety of reasons, including structural complexity, ease, and cost, they've elected to cease engaging personal service companies through any medium. Whilst compliant and in some respects a simple approach, it can be argued that such blanket bans are not in the spirit of the legislation and are likely to cause retention, resourcing, and project delivery problems. We have seen some hardline approaches revised to accommodate these challenges, but others are maintaining this firm blanket ban position. The second and third approaches involves undertaking IR35 assessments, but start from different assumptions. The second, conservative position, assumes all contractors are in scope until proven otherwise. This view may have been taken due to awareness of existing control or supervision or other assessment criteria knowledge. It's a simplistic approach that's likely to lead to challenges and appeals. It's not, however, a blanket ban and should be based on sound assumptions regarding the client's relationships with personal service company workers. It will require access to an assessment methodology for challenges or appeals, and processes may become a little bit confused. We've seen assessment costs with this model covered by the end user, or built into fee payer charges, or even covered by the personal service company. The third approach is more progressive in that the starting position is to augment the current status of engaging personal service companies and keeping them at arm's length from the business, treating them differently to staff, and utilising such resources for particular projects. This model will require an assessment process. It does require some work to establish, but it is compliant and obviously within the spirit of the legislation, in that each assignment is assessed on its individual merits. The formal process will accommodate appeals, but they should be straightforward given a full assessment has been carried out. The approach is also more likely to retain resources. We can't recommend the fourth model that we've witnessed, which is a do-nothing approach. Clearly this isn't compliant, as ignorance isn't an excuse in the eyes of the law, and it is likely to accrue liability for the end user. That brings us to the end of this presentation. The final presentation in this series has a look at the various engagement models that are available to end users. Thank you.